Yes, good evening to the aspirants of the JCJ, Junior Civil Judge 2022, which is going to be conducted on 13th of August. That's the screening test, which is the multiple choice. Now, anyone can participate, anyone can mute and read what I posted on the screen so that I could know that you are with me and I am with you and both are traveling the same boat. Quick.
MCQs on Indian Evidence Act 1872.
Say it loudly. Speak loudly. Keep the near your laptop or the smartphone.
Okay, can you hear me now?
Yes.
MCQs on Indian Evidence Act 1872. Good evening, namaskar, assalamu alaikum, etc., etc., etc. Mr. K. Sharad Babu, Professor M.S. Hussain, Miss M. Srividya.
Yes. Now the first one is Sharad Babu. Are you ready?
Yes, sir, I am ready.
Yes.
Good evening.
Sharad Babu, he was my ex-student and he's hosting from the USA, that is San Francisco State. Please go.
Yes, sir. First question is, the interpretation for court in Indian Evidence Act 1872 doesn't include option A, all judges, option B, all arbitrators, option C, all magistrates, option D, all persons legally authorized to take evidence.
B, all arbitrators. Option B, all arbitrators.
Yes, option B is the correct answer, all arbitrators. Now, second question is, document means any matter expressed or described upon any substance, and documentary evidence is defined in section dash of evidence, Indian Evidence Act 1872, A 2, B 4, C 3, D 5.
Option C. Option C.
Yes, option C 3 is the correct answer. Section 3 is the correct answer. Next, third question is, truth sits on the lips of the dying person, or a man will not meet his maker with a lie in his mouth, or no one at the point of death is presumed to lie. Each one of the above is meaning or interpretation of the maxim. A. Cogitationis penum nemo paciter. B. Nemo moriturus praesumiter mentire. C. Nemo debet bis vexari pro una et idem causa. D. Actio personalis moriter cum persona.
Option B is the correct answer. Nemo moriturus praesumiter mentire.
Option C. Option B.
Option B is the correct answer.
Option
Nemo
B is the correct.
moriturus praesumiter mentire. Anyhow, with death, that is moriturus is related. So you keep that in your mind.
I kept the feedback. Okay, no matter.
Fourth question. Taking as true without examination or proof is option A, assumption, option B, verification of proof, option C, ratification of proof, option D, presumption.
Option D, presumption.
Yes, option D is the correct answer, presumption. Fifth question. Law of evidence is A, lex fori, B, lex loci, C, lex situs, D, lex talionis.
Option A, lex fori.
Can you say the meaning of lex fori?
Course of proceedings.
Yes, it is the law of the
Of
court in
proceeding.
which a proceeding is brought. It is the law of the court in which a proceeding is brought. Sixth question. The Indian Evidence Act 1872 is not applicable to A. Judicial proceedings, B. Court-martial convened under the Army Act, C. Affidavits, D. All of the above.
Option B, court martial conveyed under the Army Act. Option B, court martial conveyed under the Army Act.
D. All of the above.
Option
is
C,
not applicable to judicial proceedings.
affidavit.
And option C, affidavits. Option B, court martial convened under the Army Act. Sorry, the answer should be B and C. B and C.
Yes, sir.
The answer should be B and C. Court martial convened under the Army Act, and C,
Affidavits.
affidavits.
Option A, sir.
Okay, agreed.
Yes, sir. Yes, sir.
Seventh question. A document is or are A written piece, B an inscription, C a map on or an inscription and a metal plate. D all of the above.
D, all of the above.
Yes, all these are documents. Eighth question. Section 3 in Indian Evidence Act 1872 is named as option A short title, B relevancy of statements, C interpretative clause, D evidence.
Option B, interpretative clause. Option C, interpretative clause.
Yes,
Option
option
C.
C is the correct answer. Interpretative clause. It is named as interpretative clause in the Ware Act. Ninth question. A sues B for 1 lakh rupees and shows entries in his account books showing B to be indebted to him to this amount. The entries are A relevant and no further evidence is needed. B irrelevant. C relevant but insufficient without other evidences. D none of the above.
Option B, irrelevant.
Option C.
Option B.
Option C. Relevant but
C.
insufficient without
irrelevant.
the
Option C
other
is correct.
evidence. Option
Yes,
C.
option C is the correct answer. Relevant but insufficient without other evidences. Section 34 Indian Evidence Act 1872 says it. 10th question. A heard a gunshot. When he arrived at the spot, the accused was standing on dead corpse with a smoking pistol in his hand. The evidence is A direct, B real, C circumstantial, D hearsay.
Option C, circumstantial.
A. Direct.
Option B. Hearsay.
Option
No, it's
C
not-
is
it's
the
not
correct answer. It is
Circumstantial.
circumstantial evidence. 11th question. In which case the Supreme Court held that the circumstantial evidence should be of conclusive nature and should exclude every other hypothesis but the one proposed to be proved. A. Miss Ayushi Vyas versus State of Madhya Pradesh. B. Hanmant versus the State of Madhya Pradesh. C. Roop Kumar versus Mohan Tedani. Option D. Bodhraj versus State of Jammu and Kashmir.
Option A.
Option B.
Op-
Naman versus State of
Option D,
Madhya
sir.
Pradesh.
Are you sure?
Option
Yes.
D.
Option B is the correct answer. Hanuman versus the State of Madhya Pradesh. 12th question. Akash is accused before the Court of Session of attempting to murder a police officer whilst on his trial before Sharma, a sessions judge. Sharma is a sessions judge. According to Section 121 of Indian Evidence Act 1872, A. Option A. Sharma, the sessions judge, may not be examined as to what occurred. B. Sharma, the sessions judge, may be examined as to what occurred. C. Either A or B. D. Neither A nor B.
Option C, either A or B.
Option B is the correct answer.
A is the correct answer. A.
Option B is the correct answer, sir. Sharma, the sessions judge, may be examined as to what occurred. Next question. According to Section 134 of Indian Evidence Act 1872, the number of witnesses A shall not exceed 2, B shall not exceed 3, C shall be any number, D none of the above.
Shall be any number. C.
D, none of the
Yes.
above.
None of the above.
D, none
Shall,
of the
shall.
above. None of the above.
Option C is the correct answer. Shall be any number. Maybe any number. Yes. Next question. 14th question. A shows B for money due on a bond. The execution of the bond is submitted, but B says that it was obtained by fraud, which A denies. If no evidence were given on either side, A would succeed as the bond is not disputed and the fraud is not proved. Therefore, the burden of proof is on B. It is in accordance with A. Section 101 of IEA 1872. Option B. Section 103 of Indian Evidence Act 1872. Option C. Section 104 of Indian Evidence Act 1872. Option D. Section 102 of Indian Evidence Act 1872.
Option D,
Option
section
D is the
102 of
correct answer. Section 102.
Yes, option
option D.
D
Burden
is
on
correct.
both of.
Yes, burden is on B. Burden is on B, not the owner. That's next, 15th question. The evidence law is mainly based upon the strong work of A. Sir James Fitzgerald Stephen, B. Sir James Fitzjames Stephen, C. Baroness Peacock, D. None of the above.
D, none of the above.
B. Option B.
Yes, option B is the correct answer. Sir James Fitzjames Stephen. In some books, it is also given as Sir James Stephen and Sir James Fitz Stephen also. But as for my knowledge, that is Sir James Fitzjames Stephen. In most of the books I found it. 16th question. In which criminal appeal case or cases the apex court ruled that benefit of doubt, if any, should be given to the accused? Option A, Harendra Narayan Singh versus State of Bihar. Option B, Dilip versus State of MP. Option C, in both A and B. Option D, neither A nor B.
Option B, Dilip
Option
versus
A.
State of MP.
In both the
Option A.
cases, in option A and option B. So C is the correct answer in both A and B
Both A and
cases.
B.
If the circumstantial evidence is with the a part of it is with the prosecutor and a part of it is the accused, then the accused is given the benefit of doubt. 17th question. Improper admission of or rejection of evidence is not a ground for retrial. It is according to option A, section 167, section 164 is the B option, section 160 C option, option D is 166.
Option
167.
A,
Option A,
167.
167.
Option
Yes, option A is the correct answer, 167. 18th question. A shows B on an agreement and gives B notice to produce it. At the trial, A calls for the document and B refuses to produce it. A gives secondary evidence of its contents. B seeks to produce the document itself to contradict the secondary evidence given by A, or in order to show that the agreement is not stamped. He is not entitled to do so. It is stipulated as per section dash of Indian Evidence Act 1872. Option A 161, option B 160, option C 164, option D 163.
Option D, 163. Option D, 163.
164.
163.
Option D, 163.
Option C is the correct answer, 164. Later on, he is not permitted to produce the original agreement. Once he denies, then later he cannot produce it. That the person who has taken the who says that originally to him. 19th question. The Supreme Court has decided that tape record is a documentary evidence and it is relevant in res gestae in option A, R.M. Malkani versus State of Maharashtra. Option B, Ashok Kumar Thakur versus Union of India. Option C, Navtej Singh Johar versus Union of India. D, none of the above.
Option C. Now.
Option A, RM Malkani,
Option
State
A.
of Maharashtra.
Option A.
Yes, option A is the correct answer. R.M. Malkani versus State of Maharashtra. In this case, Supreme Court held that tape record is a documentary evidence and it is included relevant in res gestae. Now, 20th question. The apex court has decided that the part of a film of CCTV camera footage is the best evidence in the case of A. Mohammed Salimullah versus Union of India. B. Om Prakash versus State of UP. C. Rajbala versus State of Haryana. D. Tommaso Bruno versus State of UP. Yes, option D is the correct answer. Tommaso Bruno versus State of UP. In this, the apex court held that a part of film of CCTV camera footage is the best evidence. 21st question. The proceedings related to electronic documents are included in the Evidence Act after enactment of A. Evidence Amendment Act 1989, B. CRPC Amendment Act 1973, C. Right to Information Act 2005, D. Information Technology Act 2000.
Option D, sir, Information
Option
Technology
D.
Act.
IT Act
Option
2000.
D is the correct answer. Information Technology Act 2000. After it was enacted, all these electronic documents were considered in Evidence Act. 22nd question. The plea of LB should be established by option A, prosecution, option B, accused, option C, either A or B, option D, none of the above.
Option B, accused.
Yes, option B, accused. He himself has to prove the LB, plea of LB. 23rd question. A prosecution witness, by viewing a NDTV's news film, identified the accused as a member of a group of persons who had caused serious public disturbance. The original film was retained by NDTV, and at trial, the prosecution relied on the video cassette, which the court was satisfied was an authentic copy of the original film. The evidence is A. Admissible, as the rules for submitting primary documents cannot be extended to films. B. Is not admissible, as the original is in existence. The secondary document cannot be used. C. Is not admissible, as the court is competent to order NDTV to submit the original film. D. Is admissible, as the original document is a public document.
Option C.
Option A is the correct answer. It is admissible, as the rules for submitting primary documents cannot be extended to films. This rule cannot be extended to films, and so a copy of that is enough. Next question. 24. Which of the following statements are true regarding difference between res judicata and estoppels? A. Estoppels outs the jurisdiction of the court. Res judicata shuts the mouth of the party. B. Estoppels belongs to the procedure. Res judicata is part of law of evidence. C. Estoppels prevents a man saying one thing at one time and opposite at another. Res judicata precludes a man averring the same things twice over in successive litigations. D. All of the above.
C.
Option C, sir.
All of the above.
C or all of the
C.
Option C.
Option C is the correct answer. Estoppels prevents a man saying one thing at one time
Other
and
thing other
opposite
time.
at another. Res judicata precludes a man averring the same thing twice over in successive litigations. Now, 25th question. A university was charging different fee from different batches and the batch B was subjected to a higher, and the structure of the fee was clearly disclosed in the prospectus. Can the students
In batch A, challenge the validity
Yes.
of the fee structure.
yes, can the students in batch B challenge the validity of the fee structure? Option A, no. Applicability of promissory estoppel stops them from challenging the structure. B, no. They, by taking admission, gave up the right of parity treatment with others. C, yes. There is no ground for stopping them from challenging the validity of the fee structure. Option D, no. By accepting the admission, they have waived their right to object.
Option D.
No.
Option D.
C, sir. Option C, sir.
Yes, option C is the correct answer. There is no ground for stopping them from challenging the validity of the fee structure. They can challenge against the higher fee because it was already, they cannot be stopped, even though it is in the prospectus. So that's all, sir.
Okay, thank you very much, Korikanda Sharat Babu. Now the turn is, are you ready, Motamari?
Yes, sir.
Yes, now switch on to the Motamari. She was my ex-student from India. Yes, go and shoot one.
Yes, sir. First question, evidence given by dumb witness in the court by writing or signs shall be deemed to be option A, documentary evidence, option B, oral evidence, option C, neither A nor B, option D, none of the above.
Option B. Oral
Option
evidence.
B is correct answer. Oral evidence.
Yes, option B is the correct answer. Second question, a prosecution witnesses by viewing a, I think this is completed. Sharat Babu sir already dealt with this question.
Okay.
Third question,
Switch over to the
in
next.
which of the following, third question,
Yeah, just scroll it. Let me scroll it. Yeah.
in which of the following circumstances will Section 71 of Indian Evidence Act 1872 not apply? Option A, in case the attesting witness turns hostile. Option B, in case out of two attesting witnesses, one failed to prove the execution of the will. Option C, in case the attesting witnesses does not recollect the execution of the document. Option D, in case the document is a will or testamentary document.
Option C.
Option C, the correct answer.
Option B is the correct answer. In case out of two attesting witness, one failed to prove the execution of the will. Fourth question, which of the following statements hold true under the provision of Section 73 of Indian Evidence Act 1872? Option A, the writings obtained under this section will fall within the expression evidence. Option B, the court can send the documents to an expert who is a prosecution witnesses. Option C, the court can call upon the accuser to give his writings in court. Option D, the person required by the court to give an specimen cannot confess to do so.
Option C.
Option C. The
Option
court
C is the
can call
correct
the
answer.
Yes, option C is the correct answer. The court can call upon the accuser to give his writing in court. Fifth question, which of the following document is not a public document? Option A, registered power of attorney. Option B, records of nationalized banks. Option C, a death certificate. Option D, certified copy of annual return of the company is a public document.
A.
Option
C is
A.
not it.
C.
Option A is the correct answer. Registered power of attorney.
Attorney.
Yes. Sixth question. A marriage certificate, option A, is a proof of valid marriage. Option B is determining factor regarding the validity of the marriage. Option C is of great evidentiary value in family matters. Option D, all of the above.
Option D. All of the above. Option D. All of the above.
Option
A.
C is a great evidentiary value in the family matters. Seventh question, which of the following section of
Please
Indian
give the
Evidence
correct
Act?
answer. What is the answer for
Option
that
C,
one?
sir. Option C.
For the question.
For sixth question, option C is the correct answer.
Very good, very good. Go ahead.
Seventh question.
Yes,
Which
sir,
of the
may I have
following
mute?
section-
Yes.
which of the following sections of Indian Evidence Act deals with the questions lawful in cross-examination? Option A, section 139. Option B, section 166. Option C, section 140. Option D, section 146.
Option A.
139.
Once again, read the question.
Option D, section 146.
Yes, option D, section 146 is the correct answer. Eighth question. Eighth question. Section 35, read with section 74, Indian Evidence Act, presupposes that option A document produced is really and exact from the official register. Option A. Option B, a document produced is partially an extract from the official register. Option C, a document produced is not always an extract from the official register. Option D, none of them.
A.
Option A.
Yes, option A is the correct answer. Ninth question. Additional evidence means option A, evidence let in appeal before the trial has closed in the lower court. It is a privilege allowed only under special circumstances. Option B, evidence let in appeal after the trial has closed in the Supreme Court. It is a privilege allowed only under the special circumstances. Option C, evidence let in appeal after the trial has closed in the lower courts. It is a privilege allowed only under special circumstances. Option D, none of them.
Option C.
Yes, option
Up.
C is the correct answer.
Option
After the
C.
trial has closed in lower court. Option C is the correct answer for ninth question. 10th question. Which of the following sections of Indian Evidence Act deals with the oral evidence which must be direct? Option A, section 52. Option B, section 62. Option C, section 65. Option D, section 60.
Option D,
60.
section 60.
Yes, option D, section 60 is the correct answer. 11th question. Section 130 of Indian Evidence Act protects a witness who is not a party to the suit in which he is called for producing. Option A, title deeds of any property. Option B, any document in virtue of which he holds any property as pledgee or mortgagee. Option C, any document, the production of which might tend to criminate him unless he has agreed in writing to produce such document. Option D, all of them.
Option A. Title is to any production of which.
Option C.
Option C is the correct answer.
Option C.
Option D is the correct answer, all of them. 12th question. Section 81 of Indian Evidence Act deals with which of the following documents which shall be presumed to be genuine? First one, gazette. Second one, gazettees. Third one, newspaper or journals. Fourth, every document directed by any law to be kept by any person if the document is kept substantially in the form required by law and is produced from proper custody. First option 1, 3 and 4. Second option 2 and 4. Third option 1, 2 and 4. Option D, all of them.
Option A, 1, 3, 4.
C. Option C. Option C.
Everything is correct, all of them. Everything can be presumed to be genuine.
Newspapers and
question.
journals are not presumed.
They are presumed. We'll
Hope
check
good
it again.
answer.
If we are option D is the correct answer, sir.
Okay, next.
13th question. The good faith of a sale by a son just come of age to a father is in question in a suit bought by the son. Applying section 111 Indian Evidence Act, option A, burden of proving the good faith of the transaction is on the son. Option B, the burden of proving the good faith of transaction is irrelevant. Option C, burden of proving the good faith of transaction is on the father. Option D, none of them.
Will you please
Option C.
Yes.
Option A.
C.
None of the.
Option C.
Yes, option C is the correct answer. Burden of proving the good faith of transaction is on the father. 14th question. The use of secondary evidence under Section 33 of Indian Evidence Act is limited to which of the following conditions? Option A. If the proceedings was between the same parties or their respective representatives in interest. Option B. If the adverse party in the first proceeding had the right and opportunity to cross-examine. Option C. If the questions in issue were substantially the same in first as in the second proceedings. Option D. All of them.
Option D, all of them.
Yes, option D is the correct answer for section 33. 15th question. Under section 65, Indian Evidence Act, which of the following needs to be proved concerning secondary evidence? Option A, existence of a document. Option B, condition of a document. Option C, contents of a document. Option D, all of them.
Option D.
All of them. Option C, contents of a document.
Option D, it's regarding everything, existence, condition, and contents of the document. Yes. 16th question. What do you understand by depositions? Option A, it's a part and voluntary. Option B, it is evidence given by witnesses under interrogatories, oral or written, and usually written down by an official person. Option C, it is a mere voluntary act of the party making the oath and maybe and generally is taking without the cognizance of the one against whom it is to be used. Option D, both A and B.
Option
D,
C.
both A and B. Option D, both A and B.
Yes,
Option
option D, both A and B are the correct answer regarding depositions. 17th question. When it is an inquiry said to be judicial, option A, if its object is to determine jural relation between one person and other, or a group of persons, or between him and the community in general. Option B, if its object does not require discretion to be exercised and non-judgment is to be formed. Option C, if its object requires jural relationship to be established between the judge and a group of persons. Option D, none of them.
Option A.
Yes, option A is the correct answer. To determine the jural relationship between one person and another, or the group of persons, or between him and community in general. 18th question. Which of the following are some of the instances of notifications or rules of which judicial notice was taken? First one, the Army Regulation and Ordinance issued by the Government of India. Second one, notification of appointment of a drug inspector under Section 21, Clause 1 of the Drug Act of 1940. Third one, the rule made under the Rule 225 of Printing Manual publication published by the Government of Madras, providing for return of old and obsolete stamps to the government press on receipt of new ones. Fourth one, a notification issued by government declaring Malars to be socially and educationally backward classes. Option A 1, 3 and 4. Option B 1, 3 and 2, 3 and 4. Option C 1, 2 and 4. Option D all of them.
Option D, all of them.
Yes, option D all of them are the correct.
Verna,
Please
mute.
unmute. Please mute. 19th question. Which of the following has been replaced by the Repealing Act 1938? 1 of 1938. Option A, Section 1 of Indian Evidence Act. Option B, Section 2 of Indian Evidence Act. Option C, Section 3 of Indian Evidence Act. Option D, Section 4 of Indian Evidence Act.
Option B.
Option B,
Option
Section
B.
2 of
Section 2 of
Indian
India.
Evidence Act.
Yes, option B is the correct answer. 28th question. Which of the following is important to make the evidence of witnesses relevant under Section 50 of Indian Evidence Act? Option A, the witnesses must have special means of knowledge with regard to existence of the dispute relationship, either as a member of a family or otherwise. Option B, the
Will
witness
you
must
please scroll up?
Is it visible now?
Very much visible.
Scroll up.
It is very much visible.
I think you are having a network issue.
सर तेरा फॉन्ट साइज बड़ा कर देना 43 रखा इसको 50 कीजिए ना इसको इधर प्रेस कर दीजिए ना इसको इधर
Read.
Yes.
Yeah. Yes.
Option
yes,
B,
yes.
the witnesses must depose to his own conduct towards the person whose relationship is in dispute. Option C, either A or B. Option D, both A and B.
Option D, both A and B.
Yes, option D is the correct answer regarding Section 50 of Indian Evidence Act. 21st question. Which of the following is true of Section 48 of Indian Evidence Act? Option A, it deals with the opinions as to existence of the general customs and rights when the court has to form an opinion as to its existence. Option B, the explanation to the section states that the customs and rights common to any considerable class of persons would also come within the expression general customs or right. Option C, it deals with oral evidence given in court by the person expressing the opinion. Option D, all of them.
B is the correct
Option
answer.
D, all of them. Option
Yes,
D,
option
all
D
of
is the
them.
correct answer. I think many of
Okay.
you are aware of the sections. It's very good. 22nd question. Which of the following proviso of Indian Evidence Act enable the court to require the production of material things for its inspection? Option A, proviso 5 of section 57. Option B, proviso 4 of section 58. Option C, proviso 3 of section 59. Option D, proviso 2 of section 60.
Option A, Provision 5 of
Option D,
Section
Provision
57.
2 of Section 60.
Option D,
Yes,
Provision
option
2
D is the correct answer. Proviso 2 of section 60. 23rd question. Which of the following maps are made under the authority of government? First, survey maps. Two, tak-based maps. Third, chittas. Four, superimposition of maps. Option A, 1, 3 and 4. Option B, 2, 3 and 4. Option C, 1, 2 and 4. Option D, all of them. What type of maps are under the authority of government?
Option A, 1, 3 and 4.
Option D, all of them is a correct answer. All type of maps are under the authority of government. 24th question. Which of the following section of Indian Evidence Act deals with admissions, not conclusive proof, but may be estopped? Option A, section 30. Option B, section 31. Option C, section 22. Option D, section 39.
31.
Option B,
Option B,
Option
Section
B,
31.
Section 31.
Yes, option B, section 31 is the correct answer. 25th question. Which of the following section of Indian Evidence Act deals with the facts bearing upon opinions of expert? Option A, section 46. Option B, section 49. Option C, section 63. Option D, section 50.
46.
Option
Option A,
A,
46.
46.
40.
Option A.
Yes, section
46.
46 is the correct answer. Opinion of expert. 26. Question 26. Which of the following section of Indian Evidence Act deals with the proof when attesting witness denies the execution? Option A, section 71. Option B, section 80. Option C, section 60. Option D, section 70.
71. Option A, 71. Yes.
Option A, 71.
Yes, 71 is the correct
Option A,
answer.
71.
When attesting witness denies the execution. 27th question. Which of the following sections of Indian Evidence Act deals with the burden of proof as to ownership? Option A, section 100. Option B, section 101. Option C, section 110. Option D, section 105.
Option D,
Option C, 110.
105.
Which
D,
is the
105.
correct answer?
105, sir.
Option C
Section
is the correct
105.
answer.
D is the correct answer.
C answer.
105.
Sir,
No,
1 minute, sir. Even I'm
only option C
confused.
is the correct answer.
C 1
Host.
Yes, sir. Option 10. Option C is the correct answer.
But when
Section
other
100.
people are giving that, why don't you make it out? So
Option
I say
C is
thank
the
you
correct
very much for your presentation of today of
Thank you, sir.
27 question. And it is my turn. And without wasting the time, let me go to the point. First question.
పడుకోపోరాదండి
Shravanti, mute. I could hear your all dialogues in your house.
అయిపోతున్నావు నువ్వు
Okay. First question. Evidence law is regarded as the dash which directs and assists the courts in reaching a decision when dealing with the particular case. And here the option 1, a forum law. B, Option lex loci, C option lex causae, D option all of the above.
Forum law.
A.
Can you tell me what is the formula?
Lex for sir.
It is a lex flori, law of the forum. What is the lex loci?
Limitation.
The law of the substantial law of other country. Lex causae, applicable law. Of course, the private international law terminology. Of course, I have given the feedback, but I have already given the explanation for that one. And for the immovable property, lex situs. Okay, second question. What is golden rule of evidence? A. The words of statute must prima facie be given their special meaning. B option, it is the additional and subtraction in the meaning of the statute. C option, it usually avoids unjust or absurd result in the sentencing. And D, all of the above. Golden rule, or we can also call British rule of evidence.
Option A.
Are you sure? The golden rule or a British rule is that words of the statute must be prima facie be given their ordinary meaning. Here, which is not the golden rule, I should have to say answer. Which is not the golden rule. So here they say special meaning, but I wrote the ordinary meaning. Odd man out is a very appropriate word. Odd man out is appropriate word. Is it clear? The other are very much relevant. Is it clear?
Yes.
Sir. Yes, sir.
Unless you say yes, I cannot move. Okay, now let's go to the third question. Which statement is correct among the following? A. Estoppel is the rule which prohibits a person from contradicting what was earlier said by him in a court of law. B. Res judicata is the principle which prohibits the other court forum deciding on the same matter between the same parties which has already been decided by a competent court. C option. What is the doctrine of the law? The answer is it is a single important rule, a set of rules that is widely followed in the field of law, and D is all of the above.
D, all of the above.
The statement is correct among the following. Yes, you are right. All of the above is the right answer because I did not find any mistake in anywhere. Because generally I don't give all of the above. Generally I will keep something notch over there. But anyway, that you check it again because yes, everything is quite perfect. Okay, let me presume that now there is all of the above is the answer.
Sir, all of the above is correct answer.
Yes. No, because I want to make the confusion. Other times I say all of the above, but here I made the all of the above. Then we will see that whether they give the answer on proper or not. But I can appreciate the technique that we are giving to him. They can easily shoot out. So now let us go to the next point. The law of evidence 1872, one of the below is not the feature of it. I said not the feature of the law of evidence 1872. A. Will presume. B. Will presume. C. Shall presume. D. Conclusive proof.
Will presume.
Option B.
B. Will presume.
I appreciate. Okay, now let us go to the point. Which one is not the feature of the Law of Evidence Act 1872? Disproved, B. Unproved, C. Proved, D. Not proved.
Unproved.
There is a disproved is there, proved is there, not proved is there, but unproved is not there. So the right answer for the fifth question is?
Unproved.
Unproved.
Option B. Unproved.
Okay, the sixth question. Which one is not the feature of the Law of Evidence Act 1872? A. Fact. B. Option. Material fact. C. Relevant fact. C. Fact in issue.
B.
Option B, material fact.
I appreciate. If I give the blank, it will be quite good. Because when you make the four choices, I am sure that you are definitely shooting it without any. Now you shoot this one, let me see it. Admissibility is, that is the seventh question. Admissibility is a substantial evidence of the fact. Admissibility is the substantial evidence of the fact admitted while a previous statement used to contradict a witness does not become a substantial evidence and merely serves the purpose of throwing doubt on the veracity of the witnesses was observed in the case of dash. A. P. Sarvanan versus M. Sarvasubramaniam. B. Pappu, Venkata, Lakshmi and others versus Kolli, Kolli Piditali and others. And C. N. Srihari and others versus V.N. Prakash. A. D. Bishwant Prasad versus Dwaraka Prasad. Now you shoot.
B, sir.
C.
Yes, it is the answer is the D. I don't know how you got it. Because here when I was making the board here, D something you made it or you really read it. Can you tell me that
You have
you really
already
read the
told
case
the
law?
technique of shooting.
The speaker, I mean the participant, you read this, you gave the answer. It is just you shooted, you read the case law. Give the answer. Sir, I don't know.
Sir, when three other case laws are known and they know the facts of three other case laws, then they can shoot the last answer.
Yes, but I am asking the participant what method she used it. But she's silent.
You are bolded that option D, na, sir. That's why they shooted.
She is silent. She did not give the reply to my question. Anyway, doesn't matter. Eighth question. According to the dash, the burden of proof lies on the parties to prove their case. A. Model due process. B. Process due model. C. Due process model. D. Due model process.
Due model process, option B.
Option C.
Option C is the right answer. Due process model. It is the word you used over there.
Because even the language doesn't suit also.
C is the right answer for the eighth question. Venunath, do you want to contribute anything?
I said even if you read in a plain English language, the sentence doesn't suit for other three A, B.
Your mind setup will not agree for the other thing because
Yes.
already it is framed in your mind.
Yes.
Yes,
The language is important.
that is very important.
Yeah, even the jumble words are there. It doesn't matter. You read in a plain way because already it is the software is loaded in your brain. Okay, ninth question. Which one is a false statement? A. Declaration is based on the maxim nemo maritor presumentor mentri, that the man will not meet his maker with lie on his mouth. B. Our Indian law recognizes the fact that a dying man seldom lies. C. Truth stands upon the lips of a dying man. And D. It is an exception to the principle of excluding the hearsay evidence rule. I say, which one is a false statement?
Option B.
Option D.
D.
C. Truth sits upon the lips of a dying man. Not the truth stands upon the lips of a dying man. Is it clear?
Hello.
Yes.
I'm audible, sir? Hello.
I said the C is the right answer. That's the wrong for the ninth question. Truth not stands upon the lips of the dying man. Truth sits upon the lips of a dying man. Is it clear?
Yes.
Yes, sir. It is clear.
Yes, sir.
Okay. 10th question. Section 32. Oh, I don't want to show the feedback. If you show the feedback, you can know it.
You already got the answer.
Yeah. Because when I was scrolling now, I made it a mistake.
The answer is D now.
Okay, doesn't matter. Anyway, the 32 one is not the relevant fact in the following cases when it relates to the cause of death. B. Or is made in course of the business. C. Or against the interest of the maker. D. Or that takes the opinion to a public right or a customer matters. Already the feedback I have shown it. So the D. Give an opinion to public right or customer matters. That is the not relevant to it. Because I say take, I have removed the take and made the gives. So 11th question is, I did not show the feedback now. Now I will test you. 11th question is, can anyone, okay, Reshma Parveen, can you unmute and read 11th question? I would like to see whether you could see my screen or not. I repeat. Reshma Parveen, could you unmute and read what I posted on the screen? I don't think that she is present. Anyone?
Hello, shall I read?
One of the statements not supporting the dying declaration. A. Or relates to existence of relationship. B. Or is made it will or deed relating to society. Option C. Or in document relating to transaction mentioned in section 13 class A. Option D. Or is made by several persons and expresses feelings relevant to matter in question.
Option D.
Option?
Option B.
D.
Why it is B? Give me the reason. Why
Sorry,
B
what?
is the right answer for the 11th question? Give me the reason.
It is made by one person, not several persons.
Relevant to the matter in question, that's why.
B or is made in will or deed relating to the family, not the society.
Not to the society. Yes.
I want the
Whose society?
answer also. What is the right way? Where I committed, where I made, where I deviated. Okay, next question. 12th question. In dash, Apex Code held that when a statement is made by a person as to cause of his death or as to say any circumstances of transaction which resulted into his death, in case in which cause of his death comes in question is admissible in evidence, such statement in law are compendiously called dying declaration. Number A, option A, Ulkam Ram versus State of Rajasthan. B, Pramila et Nina and others versus State. C, Vikas and others versus State of Maharashtra. D, Lakhan versus State of MP.
B. Pramila at Nena on the district.
Wrong.
Option A, Ulkaram.
Option A is the right answer. Option A is the right answer. Can you tell me how you came to know the A is the right answer?
Yes, sir.
Only you used your technique.
We read somewhere.
Give me your technique so that other people could adapt it. Sir, I shooted it because of my 11th sense, 6th sense.
That depends from person to person of using the technique.
We have read somewhere else.
It will be no. Technique will be no. That is the point. 13th question. The Apex Court in its decision in dash.
Generally, I use the
Please
technique
read me. When I was reading, don't disturb me. I repeat, when I was reading, don't disturb me. 13th question. Okay, you let the stream exhaust. Okay, you say what I want to say.
when we have not heard about the 3 other cases, then any sense of reading, any reminder of reading one case, then we can shoot it.
Yes, I asked the participants. If the participant will not give the answer, then I say host. Is it clear? Shall I proceed?
Okay. Done.
Yes, sir.
Good. 13th question. The Apex Court in its decision in dash held that the principle on which a dying declaration is admitted in evidence is indicated in Latin maxim nemo marturas proseccomitur mentri. A man will not meet his maker with a lie in his mouth. In information lodged by a person who died subsequently related to the cause of his death is admissible in evidence under this clause. In which case law it is decided? A. Sheikh Babar Sheikh Noor versus State of Maharashtra. B. Balram Dandsena versus State of Orissa. C. B. Shashikala versus State of Andhra Pradesh. D. P.V. Radhakrishna versus State of Karnataka.
Option A.
Option
Wrong.
B, Balram Dandasena versus State
Wrong.
of Orissa.
C, sir. Sasikala versus State of MP.
Wrong.
So last is D now.
Then what is the answer?
Last D. PV Radhakrishna
Deduction
was-
method. Deduction method. D is the right answer for the question. 13th question.
Sir, I have answered later.
The answer for the 13th question is D. Can I proceed?
Yes.
14th question. In dash, in which court observed Pakala ruling and said, applying this to the facts of the case, the lordship pointed out that the transaction in the case was one in which The deceased was murdered on 21st March and his body was found in trunk proved to be a bot on behalf of the accused. The statement made by the deceased on 20th March that he was sitting out to the place where the accused was living appeared clearly to be the statement as to some of the circumstances of the transaction which resulted in his death. Thus, the statement was rightly admitted. Now you tell me the which case slide is dead. I don't give the option.
Pakala Narayana Swami versus State of Haryana.
versus King Emperor. Pakal Narayan Swami versus
This
King Emperor.
answer is Wazir Chand versus State of Haryana. Answer is Wazir Chand versus State of Haryana. This decision is made. The 15th question. In the case of Dash, the accused was charged with the murder of a lady. He attacked her at midnight, but she had recognized her because there was sufficient light to identify him. When magistrate's clerk asked her about the accused to record her statement, she told that he was a Jenkins and who had done the crime. The clerk asked her that did she make the statement with no hope of her recovery of them. She replied that she was making that statement with no hope of recovery. But when the clerk read that statement over to her before her signing, she told her to add the word at present in that statement. In which case slide is decided. If I give the option, definitely you will make it out. Because in the statement itself, the word is there. A party name is there.
Clerk, C-L-E-R-K.
R versus Jenkins. Already Jenkins was there.
Jenkins who's done the crime.
Yes, that's why I made it in that manner. So now next question. It is not dragging it. Now answer also you have seen it. Because I want to drag it, but it is not accepting it when you want to go out or not. Okay, doesn't matter. Doubtful feature. In Dash, it was held by the court that second-degree burn injuries, the injured dying 7 to 8 hours after the incident, 4 dying declarations recorded, but none carried a medical certificate. There were other doubtful features, evidence not taken into account. In which of the case law? I already shown the case law. The case law name is Reshma Parveen. Read the case law because I want to see whether you could able to see my screen or not. Because you made the complaint to me that I could not see the screen.
Ramila, State of Gujarat.
Reshma Parveen. How you not present, but in the second group there are 120 are joined. In first group already it is full, but still the attendance did not increase it. What a logic. Sir,
today I have joined from group 2, sir. Sir, I am from group 2.
Yeah. Yes, what is the answer for this one? 17th question.
17.
See, here the math, the following part A and the explanation in part B I have given. Section 113A, Section 113B, Section 114, Section 114 capital A. Where the part B said, presumption as to the abatement of suicide by the married woman. B, court may presume existence of the certain fact. C, presumption as to dowry death. D, presumption as to the absence of the consent in certain prosecution for rape. Options A, 1A, 2C, 3D, 4B. B, 1B, 2C. It is.
Option D.
Yeah, just a minute. Yeah. And option B, 1B, 2C, 3A, 4D. C, 1D, 3B, 3C, 4A. D, option 1A, 2C, 3B, 4D. Which is the appropriate answer?
Option D is the correct answer.
Option D is the appropriate answer. Feedback. I am sure that I did not commit a mistake. Is it? Section 113A already made it the presumption as to the abatement of the suicide by a married woman. Section 113 capital B, presumption to the dowry death. Section 114, court may presume the existence of certain facts. Section 114 capital A, presumption as to the absence of the consent in certain prosecution for rape. Then 18th question, can anyone unmute? Reshma, Parveen, can you unmute and read? She is not present. Anyone?
She is absent. Which section of Evidence Act is relevant to criminal case only? Section 50, option B, section 51, C, 52, option D, section 53.
Option D, section 53.
Section 53 is the right answer. Feedback. Unlike a civil cases where the character is irrelevant, in criminal cases it is irrelevant. Section 53 of the Indian Evidence Act provides that in criminal cases the good character of the accused person is relevant. That is the reason even when the punishment is going on, but still the prisoners will be released on which date? Because of the good character.
15th August, 26th January.
15 August, 26 January.
October 2nd also.
October 2nd.
October 2nd, yes.
Mahatma Gandhi Jayanti.
Law Day, 26 November.
No, October 2nd generally they will make an excuse because what is the importance of the October 2nd?
Mahatma Gandhi Jayanti.
Yes, yes.
Gandhi Jayanti.
Father of the nation. Father of the nation of the India. Who is the father of the nation of the Africa? Not
Nelson Mandela.
Nelson Mandela.
No, it is South Africa.
चलो
Tanzania.
सर अभी टांजानिया इसका बोले तो किसको याद रहेगा
Jomo
सर?
Kenyatta.
It is a very much famous person. These are three persons.
Jomo Kenyatta, sir.
No, it is the Kenya.
रॉबर्ट मुगाबे.
Zimbabwe bana.
Julius Nyerere.
Julius Kambarage Nyerere. He's a teacher. He's the father of the nation. Master Tito or Master Tetler. And he's also, because there is a three members of the trio. Okay, let us come to the 19th question. Why physical evidence is the most important evidence? What they are? Which one is false one? Odd one out. Number A, fingerprints. B, footsteps impressions. C, handwriting. D, DNA.
Option D, footstep impression.
Option D, DNA.
DNA.
Option D.
DNA is scientific medical.
Fingerprints.
Right.
Footstep impression. Option B, footstep
Option D, sir.
impression.
DNA.
Footsteps impression. I said, what is the question? Did you understand?
Option B, footstep
Why physical evidence is the most important evidence? What they are? Which one is false one? Fingerprints, it is the physical evidence. Foot impression, they did not maintain in the list. Handwriting, it is a physical evidence. And the DNA, yes, it is also physical evidence. Because the feedback I have given, physical evidence can be determine the identity of the people associated with a crime. For example, fingerprints, handwritings, or DNA might prove that certain persons was present in a crime scene. 20th question. Anyone can unmute or read?
What is the best evidence in rule?
Evidence
Rule in law.
Continue.
Document partially original, recording partial genuine, photocopy of original, scan of original document for the legitimate reason.
photocopy of original. Option C.
Yes.
Option C, photocopy of original.
And here the feedback, I have given the right answer. Can anyone unmute and read the feedback?
The best evidence rule is a rule in which law states that when evidence such as documentary or recording is presented, only the originals will be accepted unless there is a legitimate reason that the original cannot be used. This rule has its origin in the 1800s.
Then what is the answer for the 20th question?
Option D.
It is
Option
not
D.
document
Scanned of
partially
original
original.
document.
It is not partially original. It is totally original. Absolute. Is it clear?
Scan of original documents for the legitimate reasons.
Yes,
D.
original document or legitimate reasons over there. Or scanned or the original document for the legitimate reason also.
Yes, D.
Yeah, that is more appropriate here is the answer we can give that D is the right answer because scanned of the original document for the legitimate reason. Is it clear? Say yes.
Yes, yes, yes.
21st question. The best evidence rule from the section dash to section of the Indian Evidence Act 1872